and that's the best. I am going to go ahead and record this, and I'll send out a recording afterwards. I'll send out a recording to everybody who attends, and I'm going to be sending out a recording to people who signed up but were not able to attend as well. I'm going to have some polls that I'm going to put on the screen in a little bit, and you should just see those polls pop up. If you can answer those questions, that would be great. It'd be good to have some interaction and be able to see where everybody's joining me from and what everybody's different situation is like. Another question that I often get is, can I see you or can I hear you? And the answer to that is no. You are private. You are in your own world there. You can hear and see me, but I cannot hear and see you. So don't worry about that. Don't worry about me having a window into your world or anything like that. I really don't. You can ask questions again by using the chat and Q&A box, and that's a great way to do that. But now it's 7 o'clock, and I really want to get us started so that we kind of reward people who are here on time, and that we can kick this off and have a great presentation or a great webinar here. So hello, everybody. My name is Timothy Scott, or TJ Scott, and I'm the owner of the law office of Timothy J. Scott. I'm an estate planning attorney, and what that really means is I help families to avoid court and conflict for their loved ones after they're gone. And I am so happy to have you here with me today. We're going to talk about something that I know is a difficult topic, but I also believe that having knowledge about this topic can really empower you. And that's what I'm here to do tonight. I'm here to educate you. I'm here to empower you to take control so that you don't have to be scared of this topic that I know is on a lot of people's minds, but is also kind of unclear and needs some explanation really to understand what it's all about and what it really means. So today I have some really valuable information that I'm going to give you and some really valuable offers that I'm going to be sharing at the end of the presentation. But before we get there, let's start with this. Let's all be present here today. Let's all bring our best to this presentation. And I want to encourage you, if you have other windows up, if you have other things going on, I want to encourage you to turn off any distractions that you have around you. I want to encourage you to give yourself this time that you've already set aside to be here with me today. And I can promise you, your future self is going to thank you that you took the time and dedicated it to learning here today and learning about this important topic. And as I said, if you stick around until the end, I have some great offers that I want to make you. One of those is I want to give you a free virtual one-on-one meeting with me where we'll have 2 hours to talk about the people that you love and the things that you have and how you can take control away from the state and the state's plan for you and implement your own plan in place. Plus, I want to give you a bonus gift to make it even easier to get a personalized and tailored estate plan in place for the people that you love. But I want to start here, and I want to start with our first poll question. And that first poll question is, do you have an estate plan? And so I often get the question in my personal life, in my professional life, what is the difference between an estate plan and a will? And really, a will is a part of an estate plan, but a will is not an entire estate plan by itself. So a will is a small part of an estate plan. An estate plan is composed of a will and other things as well. And here are some things that compose or that make up an estate plan. You often will have a trust, a will. If you have minor children, you'll also have guardianship nominations for those minor children, which says who those minor children should go and stay with and be raised by until they're 18 and they're able to be out on their own. An estate plan also often includes incapacity planning, things like who can make healthcare decisions for you, who can make financial decisions for you if you're not able to make them for yourselves. And an estate plan even reaches beyond those kinds of documents and into beneficiary designations, which you can set on things like retirement accounts and things like life insurance policies. And I'm taking a look here. It looks like of those who've participated, most people are saying that they do not have an estate plan in place. And I really appreciate you sharing that with me. It's going to help me to understand exactly where I need to put my attention and what I need to speak to here tonight. Oh, and I see somebody else in the chat as well is saying that no, they do not have an estate plan. And so thank you for sharing that. So if you don't have an estate plan, do you mind me asking why not? And I'm going to go ahead and launch another poll here, and maybe something on here resonates with you. Maybe you've been too busy. And I totally get that. As a father of three, and as a business owner and a lawyer who is constantly moving and doing different things, I completely understand. Today's world is really crazy and it is really busy. And in fact, I want to take a step back and just say you aren't alone if you don't have an estate plan in place. In fact, one figure that I've seen is 69% of Americans do not have an estate plan in place. But I also want to say, if you don't have an estate plan and you're here with me tonight, I really want to congratulate you on taking this first step to getting an estate plan in place. It's really good to have you here. Another reason that I often hear is people thinking that they're too young. And I really also understand that argument. None of us think that we are going to die, and none of us think that it could happen to us that we die at a young age. And I pray that it doesn't happen to any of us. But the truth is that anyone over the age of 18 should really have a plan in place. And I recently helped out a young family where a young father had passed away. And unfortunately, he'd left something of a mess for his wife and minor daughters. But that didn't have to be the case. He could have got planning in place. He could have taken care of them and made sure that they were really taken care of in a great way. We were able to get through it, but it was not a great situation for his family to have to go through. Maybe you're worried about estate planning being too expensive. And this is one that I hear a lot of times. And honestly, before word processing, before we had Microsoft Word and different ways of working with documents on the computer, estate planning really was just for the wealthy. Documents used to have to be filled out in triplicate, and it was a real process. If you made a mistake on one of those documents, you had to start all over again. But today, estate planning is for everybody. And I am going to have some bonuses at the end to make it even more affordable, as well as talking about exactly what you can expect to spend on a tailored estate plan that's really going to take care of your family in the way that you want it to. And maybe you're worried about jinxing yourself. And I don't see anybody admitting that they are worried about jinxing themselves. In fact, most people are saying that they're too busy, which again, I completely understand. But I can put your mind at ease if this is on your mind. I have written a lot of estate plans, and I have never seen a correlation between somebody getting their estate plan done and having something negative happen in their lives. And so I just want to put your mind at ease that isn't something that you need to worry about. I see somebody's having a little bit of technical issues, and I'm glad that you're here with me. I'm glad that you are joining me here. And I do see somebody fessed up to being worried about jinxing themselves, but again, that's not something that you have to worry about. I've done a lot of these estate plans, and I just haven't seen that connection happen before. And maybe you're coming to this webinar with a plan already in place, but you want to learn something additional here. And even if you don't have an estate plan in place, maybe there's something on this list. I just put up another poll that's really jumping out to you, and that you really would like me to speak to in particular. And I can tell you, I'm going to speak to all of these things today. Maybe you want to know if an online will is okay. Maybe you want to know if an online will is going to take care of your family in the way that you need them to be taken care of, or the way that you want them to be taken care of. They're really big right now. And I completely understand that a lot of us see them advertised. There are some real drawbacks to having an online will, and I'll make sure to talk about those, as well as specifically talking about why planning with a will has some real drawbacks and some real negatives that can affect your family. Maybe you've done an estate plan, but it's been a long time, and you're wondering, is my estate plan outdated? Do I need to update it for any reason? And I'll definitely talk about that today. The law is constantly changing, and your situation, I'm sure, is constantly changing. The assets that you have and the people that make up your family is always in flux and is always going through some kind of change. And so oftentimes, if you've had big changes in your life, or if big changes have happened in the law. And I can tell you, if you haven't updated your plan since 2019, because there was a big Secure Act update to the law in 2019, you probably are going to want to have your plan looked at and make sure that it's okay. Maybe you just want to have a better understanding of your plan. Maybe the attorney that you worked with went through everything too quickly and didn't really give you a deep understanding of your plan. And so you just want to learn some more, and you want to learn more about what goes into an estate plan and what should I really be thinking about. And if that's the case, great. You are in the right place here, and I'm definitely going to speak to that. I'm seeing a smattering of all of these different issues that people are interested in hearing about. And I really appreciate everybody who entered into the poll and gave me an answer in that poll. If there is something in particular that you want me to address tonight, or if there's a general concern that you have about estate planning that you want to make sure that I address tonight, I hope that you'll either put it in the chat box or in there should be a button that says Q&A where you can ask questions. Either of those places, I'm monitoring them constantly. That's why I keep looking over to the side here. And if I see a question over there, I'll make sure to take some time and answer it in particular so that you can have your answer tonight. Whatever reason that you're here, you are in the right place. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online will or a fill in the blank will, but you're not sure if it's going to work for your family when they need it. And you're in the right place if you're nervous about how much this is going to cost. I completely understand that. We're all living with a budget, and I will speak directly to how much estate planning will cost and how much it should cost for your family. The reality is that estate planning isn't about you. It's about the people that you love. And this is something that really occurred to my wife and I as we were going through and updating our estate plan recently. These are my 3 kids from left to right. It's Margaret, Ben, and Elizabeth. And we realized that our estate plan was never going to enrich us. It wasn't like starting a new business or something like that. But we realized that we were really doing it for our kids and for our family, for the people who were going to take care of our kids. And we were putting it in place to make sure that everybody was as well taken care of as they possibly could be. That if something happened to my wife or I, that we would have as seamless a handoff as possible, and that we could really make sure that our kids were going to thrive to the maximum extent possible, even if they couldn't have us in their lives as they grew up. And so your loved ones are going to know whether you lived up to your promise to take care of it based on how you handle this information and how you get your estate planned. Seeing a question here. My sister and I own a duplex together since the 1990s. I'm not on the mortgage, only my sister is. In the year we bought a house, a lawyer drew it up as joint tenancy. I can't remember the name of the document, and I have a copy, but haven't found it yet. She says, I hit enter, but I wasn't finished yet. Let's see here. So you're not on the mortgage, your sister is, but you own it in joint tenancy. So one thing that I'll say is owning property in joint tenancy means that when one of the joint tenants passes away, it automatically, by law, flows to the other joint tenant. And so maybe this has happened in your life that you've lost your sister recently. And if that's the case, I'm really sorry. I haven't seen that. If my sister dies before me, she said a lawyer said I get the full property, and that's exactly right. With joint tenancy, if you own it in joint tenancy, when one of those joint tenants passes away, the other owns it in the entirety. And so even if you're not on that mortgage, you can step into your sister's shoes and continue making those mortgage payments. And that's something that that you'll have the right to do, and that you can expect to do if that's what you want. So a really fantastic question just right off the bat here. If you have any other questions about that, I hope that you will go ahead and post them, and I'll be on the lookout for them, and I'll make sure to answer them as well. So here is what we're going to cover today. We are going to cover planning for incapacity. We're going to cover who can make healthcare decisions for you, who can make financial decisions for you, and what kind of documents you can get in place to make sure that the person you want to have handling your healthcare decisions and the person that you want handling your financial decisions is the person who has that authority and has that power if something happens to you and you become incapacitated. And incapacity could mean something like falling into a coma after a car accident. It could also mean something like suffering from dementia and or Alzheimer's, and seeing your cognitive abilities slip away. And oftentimes we know who that person is that we would want making healthcare decisions for us. Okay. All right, and I do see that it looks like your last name is misspelled. I'm not sure how that happened, but I appreciate you bringing that to my attention as well. Other things that we're going to learn today, we're going to learn about planning for when you pass away. And so, and in fact, I should post another poll here just to get kind of a picture and see if people are here who have young children today. And I'll make a special effort to talk about guardianship, because guardianship really only applies to people who have minor children. So you should see another poll pop up where you can tell me if you have any young kids. But if you have kids under the age of 18, guardianship is who is going to raise those kids until they are no longer a minor. There's also a special document that I'll talk about in just a minute as well, called short-term guardianship. And that short-term guardianship is really important for the moments when it becomes clear that you won't be coming home. The police arrive, and you want to make sure that somebody has the legal right to stay with those kids, because what happens when the police arrive is not always the best for those kids. We'll also talk about probate, and we'll talk about the time, cost, and public nature of probate and exactly what that means. We'll talk about estate taxes tonight. A lot of people worry about estate taxes and worry about owing estate taxes, but that's actually one place that I have some really good news tonight. We'll also talk about unclaimed property, which is something that is often not discussed in this sort of venue or this sort of arena of estate planning, but it's something that I think is really important, knowing how unclaimed property ends up with the Minnesota Department of Unclaimed Property and how you can get access to it, but also make sure that your property doesn't end up there. We'll also talk about planning for your intangible assets, things like your stories and your values that you might want to share with the generations that come after you. Now, before we get into those topics today, I want to share a little bit more about myself so that you know a little bit more about me before we start talking about those other things. So this is myself with my family, and we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Ben, Elizabeth, and Margaret. And those were not who's on screen. On screen here from left to right, it is Elizabeth, Margaret, and Ben. And my family is really my whole world. I graduated from the University of St. Thomas School of Law back in 2012, near the top of my class. And the very next day, my first child, Ben, was born. So that's me commencing on May 12th, and that's me holding my newborn son on May 13th. I found a job with a small estate planning and tax preparation law firm, and I love the clients that I was working with. But sometimes I didn't feel like I was providing the level of value that my clients really deserved. And so a little after 3 years at that law firm, I ended up leaving. And this is actually a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this was not said about me. I want to make that very clear. But this is something that has really stayed with me. My parents had an extremely negative experience working with an estate planning attorney who helped my grandmother before she passed away. And in particular, I remember my mom saying this to me about this estate planning attorney. Someone has to graduate at the bottom of the class. And there was a big reason for that. I don't think it was actually the attorney's knowledge or the attorney's ability. I don't think that they probably actually graduated at the bottom of the class. I think that there was an inherent flaw in the model of estate planning that he was practicing under. And I'm going to talk more about that faulty model. I call it planning for death a little bit later. But first, let's talk about some aspects of estate planning. And I don't see anybody posting who has minor kids, or I don't see, I don't actually see anybody posting who has minor kids, which is really rare, but that's okay. I will talk about guardianship in more brief terms and get into the heart of what probably will be more interesting to our main audience here. So I talked about this a little bit, short-term guardianship. And again, short-term guardianship is what happens when the police show up because the babysitters called them, because you haven't showed up for whatever reason, and the babysitter doesn't know what to do. And the police show up and they have to, for liability reasons and just to make sure that they're covering their own butt, they have to get Child Protective Services involved. And I'm not trying to rag on the police. I'm not trying to rag on Child Protective Services, but I can tell you that is not a situation that anybody wants for their minor kids. And so if anybody has minor kids and didn't speak up earlier, or if anyone knows anyone with minor kids and is concerned about this for them, I hope that you'll mention the importance of having short-term guardianship documents in place in addition to the long-term guardianship documents, so that somebody has the right to stay with those kids overnight and for the amount of time that it takes in order to get them to the long-term guardians. Long-term guardianship is really who is raising those kids until the age of 18. And if there isn't a plan in place, then the state has written a plan for you. And the state's plan is that a judge is going to decide who is the best person to raise those kids until they're 18. A judge is not going to know, as well as you know, as well as any parent knows, who the best person is to raise those kids and to make sure that they are in a situation where they're really going to thrive. So it's probably a plan that you're not going to like. And if Uncle Larry looks like the absolute best choice to the judge, maybe Uncle Larry has a steady job and a place where the kids can live, then he's going to send those kids with Uncle Larry. And again, nobody wants Uncle Larry to have kids. Not to throw shade at people with the name Larry, but that's just an example. You want to make sure that you get that written in a hard document and signed, so that it's really clear what should happen with those kids. So let's talk about how the people you love are going to receive your assets under your current plan or the state's plan for you. And the state does have an estate plan written for you. It's a one-size-fits-all plan called probate. And probate is a court case. It's a lawsuit that you file against yourself with your own money for the benefit of your creditors. And this is the process. Again, it's one size fits all. It's the process that Prince's estate goes through. It's the process that people with no money in their estate have to go through. And this is what it looks like. I do see something coming through here. What is a hard document? And when I say a hard document, I meant like a hard copy document, a paper document that actually has a wet signature on it, to make sure that those wishes that you have are documented in something that is signed. That's what I meant. Good question. I think I'm making up terms here, but hopefully that's understandable now. So this is what probate looks like. And there are a few things about probate that people generally don't like. First of all, probate in Minnesota is slow. In Minnesota, it takes a minimum of 6 to 12 months to get through the court process called probate. And the truth is, we'd like it to go faster, but it just can't. It is going through a court system. And so there are certain administrative barriers that are in the way. In addition, it is really for making sure that your creditors get paid. And so your creditors want the ability to come forward, and they want to make sure that there's enough time for them to find out about your probate and come forward. And so they've built in certain windows of time where you have to give them notice, and then you can't do anything until your creditors actually have time to come forward and make sure that they get paid. Probate's also very costly. There are attorney's fees and executor's fees, appraiser's fees, court filing fees, bond premiums, et cetera, et cetera. And probate in Minnesota costs, on average, somewhere between 3 to 6% of the gross value of your estate. So you can imagine, if all that you own is a house worth $400,000, probate is already probably going to cost somewhere between $12,000 and $24,000. And we'll actually have a chance in a little bit to do some back of the envelope math and calculate exactly what your own probate estate would probably cost. Probate's also public, and I'm showing you here the last will and testament of Anna Nicole Smith. wills are totally public, and having a will doesn't avoid probate. And that's something that's really important that I want to make sure that I enunciate just one more time. A will does not avoid probate. In fact, we have this really goofy saying in the estate planning world: where there's a will, there's a probate. If you are relying on a will to transfer your assets to the people that you love, the people that come after you, then you are going to have to submit that document to a probate court in order to have it interpreted and in order to make sure that your assets get where your will says that they should go. A will ensures that there's going to be a probate. And so this fact that your will has to go into the probate court, the fact that it has to go and be published and be made public, means that creditors could be on notice about what your estate has and about who is going to be receiving from your estate. And that's something that's pretty unnerving. We all know that there are some bad folks out there these days. We know that there are some folks who tend to prey on people who are less sophisticated and less able to handle themselves. And so you can imagine, if you have a healthy estate that you want to go to a particular person, maybe that person would be vulnerable to that kind of predator, and you wouldn't want predators finding out the fact that that person is going to receive an amount of assets either directly or when they turn 18, because that's another thing. Minor kids receive assets at 18 and unprotected. And I think we all know at least some lore about some stories where people receive assets at a young age, and it's a windfall, and they don't handle it well. They don't get their financial legs underneath them for years afterwards. And maybe they don't go to school and get educated. Maybe they don't find a job that is going to be rewarding and fulfilling for them. But instead, they sit back on that money that they received as an inheritance, and they squander it, and then it's gone. And again, they don't have their financial affairs in order to know what to do. So that's something that's really scary, something that you can avoid, again, with probate. If you have minor kids, you can make sure that they don't receive at 18. Another thing is there's an order of operations that happens. And so if you have children with children who are under the age of 18, if something would happen to that child of yours and the assets were going to your grandchildren, then the same thing would happen, that those minor kids, those grandkids of yours, would receive those assets at 18. And again, I just know that that's not something that I want for my kids. It's something that I know that most people don't want them to receive those kinds of assets at such a young age. So here is your opportunity to actually calculate your probate estate. And what I have here is kind of an example estate. It is, maybe it's on the high end for what you're looking at. Maybe you feel like it's on the low end. Whatever you're bringing to this, you can do this for yourself. But taking a look here, you can see that I have a family home, a rental property, or maybe that's a cabin property up north, furniture, household goods, automobiles, stocks, bonds, bank accounts, and a business interest as well. And you can see that that all adds up to $850,000. Now, in order to get 5% of the gross value of your estate, in order to get that 5% number, there's a really cool trick that I learned. You move the comma over one place, and then you divide that number in half. So we all know that you can get 10% by moving the comma over one place. And in order to get 5%, you just cut that number in half. And so that's how I got $42,500. And that would be the estimated probate costs and fees associated with this estate. And you can imagine, I mean, that's a huge haircut that your heirs would be paying, that your heirs would be taking, which could be money that would go directly to them, and instead is just going to be paid to the court, is going to be paid to attorneys, is going to be paid for a personal representative to go through everything, for appraisers, for all of these different things that just don't have to take the money away. But if you leave it up to probate, if you try and plan with a will, then this is what that might look like. And here, just to add a little wrinkle, if you have life insurance or retirement accounts that are payable to a minor, again, those minors can't receive those assets directly, at least not until they're 18. And so if it's paid directly to a minor, then those assets also have to go through probate. And so here you can see how all of a sudden the estimated probate costs and fees really balloon by the fact that these life insurance proceeds and retirement accounts proceeds end up having to go through probate because they are directed towards a minor. I've talked a lot about probate here, and I imagine that I'm probably going to get some questions about probate, although I don't see any currently filtering in. But there is a foolproof way to avoid probate, and that's by fully funding a living trust. And a living trust is a document, it's an agreement that you write or that an attorney writes that says exactly what's supposed to happen to your assets. But that agreement can also hold on to assets. It's kind of like a business in that way, where you can put assets into the agreement or into the trust. And so what you want to do is have an attorney write that trust agreement, and then you want to fund or put those assets into the trust. And so you want to retitle investment accounts in the name of the trust. That's something that you can do if you go down to your brokerage or if you go down to your investment advisor. You can ask them, how do I retitle this investment account in the name of my trust? You can also sign new signature cards at the bank that will actually put those bank accounts into the name of your trust. You execute deeds on real property. So instead of owning that property in your personal name or in the name of yourself and your spouse, you actually own that piece of land in the name of your trust, or as trustee in the name of your trust. In order to fund stock and bond certificates into the trust, you have to execute a transfer, and that's either by filling it out on the back of the stock certificate and sending it in and having it reissued to you, or if you own those stock certificates in something like a digital clearinghouse, there's generally a way that you can do that online and take care of that to make sure that it goes into your trust. Assign personal property into the name of your trust. And that's just done through a single document, either called a bill of sale or an assignment of personal property that you sign. And it says all of my personal property is hereby in the name of the trust. And then changing life insurance and retirement account beneficiary designations, that instead of having that life insurance and that retirement account directed towards an individual, you want it directed into the trust. And that makes sure that the dictates of the trust are going to say exactly what happens to those assets. It's also going to make sure that a minor doesn't receive those assets, and that if the beneficiary passes away before you pass away, that there is a succession plan in place so that the right person will receive that asset instead of having it go through your estate and go through what's called intestacy, which is where the state tries to find somebody to give that asset to. All right, now we have a chance to calculate your estate taxable estate. And I'll say estate tax is not one of the major reasons that most people do an estate plan with me. Most people do an estate plan with me because they want to take control away from the state. They don't want to have their family to have to go through that probate process. They want to make sure that their family is going to avoid court and conflict down the road after they're gone. But estate tax is real, and an estate tax does apply to some people. The federal estate tax exemption, meaning nobody owes federal estate tax until they get above this number. Federal estate tax exemption is $11.7 million. And so for your first $11,700,000, you pay nothing in federal estate tax. And there's even better news. If you're married, you get to double that federal estate tax exemption. So instead of 11.7 million, you're looking at $23.4 million that you can pass tax-free without having to worry about that federal estate tax. Once the federal estate tax does kick in, it is steep. It starts at, or it goes up to 40%, so 40 cents on the dollar above that threshold. But again, it doesn't apply to most people because the exemption is so high. In Minnesota, the exemption is lower. The exemption in Minnesota is $3 million. So for your first $3 million, you pay nothing in estate tax. But for your $3 million and first dollar, you do start paying estate tax, and you start paying at 13 cents on that dollar. And then it goes all the way up to 16%. And so you can imagine that's really taking a haircut off of the amount that you're able to give to your heirs, if that applies to you. Again, that doesn't apply to most people, but it does apply to some people. Something else that's notable in Minnesota, that $3 million is not doesn't automatically double if you're married. There is a way that you can make sure that it doubles if you're married, but you do have to do some estate planning in order to put the rules in place and in order to put the documents in place to make sure that you get that doubling. And so if you have more than $3 million and you haven't written an estate plan, or the estate plan that you've written was written sometime before about 2014, you're going to want to make sure that you have your estate plan updated to take that into account, to make sure that your estate plan, your estate tax exemption is doubled. I see somebody asking, is it possible to get a copy of your slides? And generally, I don't send out a copy of my slides, but I do send out the recording of this webinar. So let me know if that is sufficient, or if you really want a copy of all the slides, or if there are particular slides that you're interested in me sending you, and we can talk about that. Will your assets be lost to the state? So does anyone have any idea how much money is currently in our State Department of Unclaimed Property? And it's going to be a little bit of a race here. I don't see anybody trying to guess at it. But right now in Minnesota, we have more than $700 million in the Department of Unclaimed Property. And a big part of the way that that money gets there is that somebody passes away, mom or dad passes away, and the kids aren't entirely sure about all of the bank accounts or all of the investment accounts that mom or dad has. And I can tell you, when we do probate, a lot of times what we do is we go through the mail of the person who has passed away and we look for statements. And that's how we can find bank accounts. But right now, with electronic statements turned on for so many people, that's becoming less and less effective in order to find those, to be able to find those bank accounts and find those investment accounts, and to make sure that they get to the people that that the deceased wants those assets to go to. And so this is something really concerning. It's something that, again, a lot of estate planning attorneys won't touch, but I think is so fundamental. And especially if you don't have a lot of assets, you want to make sure that the assets that you have get to the people that you want to receive them. And part of that is making sure to create an inventory and create a stock, or to take stock of the assets that you have, so that each of those assets is accounted for when you eventually pass away. And we're all going to pass away. When you eventually pass away, you want to make sure that there's some kind of inventory that the people that you love can follow, to make sure that they're able to collect all of the assets that you had. This is really cool. You can actually make your estate plan a real gift to your children or the people who come after you by giving them something called asset protection. And asset protection means that their inheritance can be protected so that it can never be taken away by a spouse in a divorce, or even touched if your child is in a car accident or sued at some point in the future. This is so cool. This is something that we can actually build into that inheritance. It's something that's almost impossible to build in yourself, or to create for yourself or for your own assets. And a lot of people will try. A lot of people go to Nevada or South Dakota or even Alaska in order to build these types of asset protection trusts. But your inheritance can be protected in this type of asset protection trust that often costs something like $20,000 to $40,000 for these asset protection trusts to be written. The inheritance can be protected in this asset protection trust for much, much less, for much, much cheaper. And this is so cool. I love being able to do this. I love being able to help people get this protection for their kids' inheritance, and make sure that they're able to enjoy, that your kids, or again, whoever is coming after you, is able to enjoy that inheritance and use it for what you would want them to use it for, as opposed to having to say goodbye to half of it in a divorce decree, or losing it to a creditor in something like a lawsuit. So this is something that I know is very real for a lot of people right now. The person on the screen is Terri Schiavo. And many of us probably remember Terri, and we remember the court cases that erupted across the United States involving Terri and involving Terri's care. Terri was in a coma, and she was in a somewhat vegetative state where it wasn't clear how much Terri was able to function in the real world anymore or interact with the real world anymore. And there was a disagreement. There was a disagreement between Terri's husband, who thought that Terri wouldn't want to live like this and would want to have her feeding tube removed, would want to have her nourishment removed, and would want to be able to pass away peacefully. And there was a disagreement between the husband and this view of what Terri wanted and what her parents thought Terri wanted. Her parents thought that Terri would want to stay alive at every means possible so that she could continue whatever limited enjoyment of the world she was able to receive. And I don't know what is accurate. I can tell you, Terri did not put her wishes into something like a healthcare directive that would have given guidance to her husband and would have given guidance to her parents. And what ended up happening was there was a lot of conflict, and there were court cases, and it was just a really unfortunate case for everybody that you ended up having all of this conflict, and the conflict spilled out even beyond the family to where everybody in the United States was asked to weigh in on this and was starting to think about Terri's situation and guessing at what Terri would want. And I can tell you, I don't know what Terri's wishes about her healthcare would be, but I can tell you that almost certainly wasn't her wishes about how her name was going to be remembered and about how people were going to experience and know who she was. So I've talked about a lot of things tonight. I've talked about a lot of things, and you're probably thinking right now, what can you do today to do the right thing for your family, and what should it cost to plan right? And really, with all of the things that I've talked about, you're probably thinking to yourself, I know that I need to get some kind of plan in place, but I don't know, maybe I should just do it myself, or do I need to work with an attorney? And so I'm going to try and answer that question for you. I'm going to try and answer the question of whether you would benefit from working with an attorney. And I'm also going to try and help you answer the question of choosing that attorney and what to look for in the attorney that you might work with. And so let's answer this first question. Should you do it yourself, or should you work with an attorney? And I can tell you, you would probably benefit from working with a lawyer if you own more than just your personal belongings, things like cars, clothing, jewelry, and furnishings. If you own more than that, if you own real estate, if you own your home that you're living in, if you own more than $75,000 in assets, all told, then you would really benefit from working with an attorney, because your estate at that point is subject to probate. And avoiding that probate is something that I know is really important to a lot of people. If you want to ensure that the people that you love stay out of court and out of conflict, and they have somebody to turn to when something happens to you, then you would benefit from working with an attorney, somebody who is a professional and who can help you get the plan in place that's going to take care of your loved ones after you're gone. And if you want a kids protection plan, which includes that long-term guardianship, as well as short-term guardianship, and other documents that are going to make sure that those kids are taken care of in different situations, like if there's a medical need while you're out of the state or out of the country, then you must work with an attorney in order to get that in place. If you want to avoid probate or estate taxes, or if you want to protect your children's inheritance in something like an asset protection trust, then you really have to work with an attorney. And if you want to guarantee that your plan is going to work when your family needs it to work, then you have to work with an attorney. And this is something that I was thinking about the other day. It was actually, you say the other day, it was over a year ago now. And I was putting fishing line on my son's rod and reel. And I was putting fishing line on his, and I was putting fishing line on my own rod and reel that they had been delivered to the house for whatever reason without that on it. And so I was in the process. I thought that I had everything going right. And I snipped the fishing line, and all of a sudden it started jumping off the reel, and there was fishing line tangled everywhere. And I just sat there and stared at it as it was jumping off of the reel, just kind of in disbelief. But that was okay. I was doing that project myself, and I had some immediate feedback that clearly I had done something wrong. And I was able to take that fishing line, I was able to cut it off at a point and deal with the tangles and make sure that everything was okay. And my son and I were able to go out and we were able to fish that day. Not a problem. I had immediate feedback that my do-it-yourself project had just miserably failed, right? Unfortunately, when you're planning for something like your death, when you're doing estate planning, you aren't going to have that immediate feedback that the plan that you've written isn't going to do what you want it to do. I've seen a lot of people who have tried their best to write an estate plan that's going to take care of their family. I've seen a lot of people who have tried to get that plan in place to make sure that their family would stay out of court and conflict, who unfortunately have unwittingly put their family into additional court and conflict that they should never have had to deal with. And it's just a sad reality of life that that it is a very complex area. It's a very complex thing to handle and a complex thing to do. And it's not something that you want to try and do yourself, because again, you're not going to have that immediate feedback, and you're not going to know exactly what your plan is going to mean for the people that you love. Something else to think about: if you want to give your assets to someone other than your kids, if you have some sort of distribution in mind that goes beyond them or that goes to a different person, maybe it's a friend or something like that, then you really want to work with an attorney and make sure that that's drafted in exactly the right way. I see somebody posting here, is there a guide to follow to complete a proper healthcare directive? Was just reading and helping my mom, but unclear what to put in on our own. And I hope that you'll reach out to me afterwards, and I'm happy to provide some guidance on exactly how to complete that healthcare directive. There are, I'm not exactly sure where you're running into issues with it, but again, I just hope that you'll reach out to me. I'm really happy to help you with that at no cost, and just make sure that that's going well for your mom, and that that's not an issue for her. So I want to go back to this quote that I said earlier in the webinar. Someone has to graduate at the bottom of the class. I mean, now you probably know whether you would benefit from working with an attorney, but you really need to know if you are working with the right attorney, or if you're working with one of these attorneys who is planning for death, planning under this faulty model where they're not really serving their clients in the best way possible. And this is what that experience that my parents had, that experience that my grandmother's estate planning attorney really put them through. This is the model that estate planning attorney was going through. And I, again, call it planning for death. And the typical experience is that attorney is going to use form documents that are kind of set it and forget it documents. You put them in your drawer and you forget that you even completed them. The attorney probably didn't walk you through the documents or explain exactly what was happening. They probably just filled your name in on some of them and hoped that it was going to take care of you when it's not always clear that it would. That typical experience also isn't going to keep money out of the Minnesota Department of Unclaimed Property when something happens to you. It's just not something that most estate planning attorneys think about, but it is something that I think is foundational and important. Typical experience may avoid probate, but it may not. It's probably not going to keep your family out of conflict. The typical experience is only going to focus on money. It's not going to focus on your stories and your values and your insights that you might want to share with the people that you love. The typical experience is going to leave assets to heirs unprotected. It's just not something that the typical estate planning attorney builds in. They don't build in that asset protection. It's not something that they know how to do. Typical experience is not going to provide ongoing legal guidance. Again, you're just going to take those documents away after you've signed them, put them in a drawer, and probably never think about them again and never update them. Typical experience also is going to charge hourly fees for any future needs. And so you're not going to want to reach out to that attorney with any changes that happen. You're not going to want to interact with them, because every time that you interact with them, you're going to end up with another bill in the mail for that interaction. Typical experience is not going to adequately protect kids, and that's minor kids, and making sure that they have a full kids protection plan in place. And really, you're going to end up with this question at the end of working with a typical estate planning attorney: is my plan going to work when I need it to work? And in my opinion, that's a question that you should never have after you've hired an attorney and after you've worked with an attorney. And that's why working with me is completely different. It's a whole different experience. And I really call it planning for life, because that's what I think it is. I want it to give you assurance. I want it to make you feel confident that you know exactly what your family, how your family is going to be protected when you can't be there to protect them anymore. So planning with me, I only charge flat fees, and you actually get to choose your own fee in the meeting that we have together. And that doesn't mean that that I'm going to rely on your benevolence to pay a fee that's going to keep food in the mouths of my children. But what it means is that I have different planning packages, and you choose the package that is going to take care of your family in the best way that your budget allows. And whatever that is, I will help you to walk through that, and I'll help to make sure that that the plan is going to do what you want it to do. Planning with me is going to keep your money out of the hands of the state. I create an inventory for all of my clients to make sure that all of their assets are shepherded to the people that they want to receive those assets. I think that is so fundamental. That's so important to make sure that that your heirs receive everything that you want them to receive. Planning with me protects your kids totally, both immediately in that short-term guardianship situation, as well as the long-term guardianship situation. Planning with me keeps your family out of court and out of conflict. You're going to be able to avoid probate, and you are going to know exactly how to fund your trust and how to make sure that everything is where it belongs, so that you can get that probate avoidance. Planning with me means that you're going to know that you've made the right decisions. We're going to walk through it together. I believe so strongly in educating and empowering my clients and making sure that they know exactly what they're doing and what they're signing. And that is foundational to me, that you understand everything that we're walking through and everything that we're doing, that you understand your plan completely. It is your plan, and you need to be educated enough to make the decisions in that plan that are going to affect your family in the way that you want them affected. That's really going to take care of your family in the way that you want them taken care of. Planning with me means that you can protect the family money from outsiders. You can protect that inheritance from things like divorce, from things like creditors that might try and sue and take that money from your heirs, from your kids. And planning with me means a lifetime of guidance and protection. Again, I charge flat fees. And I'm not going to charge you when you want to call me and tell me that your first grandchild is born, or when you want to call me and tell me that you found the absolute house of your dreams and you're so excited to move. I want to hear about that, and I want to celebrate that with you. And if there are changes to your plan, there may be some additional fees, and we'll talk about it at that time. And we'll make sure that we agree on a flat fee that makes sense to you, and that makes sense that you would want to get those things done. But I'm not going to charge you for emailing me. I'm not going to charge you for calling me, because we have to stay in contact. We have to have that attorney-client interaction all the way along to make sure that your plan is really doing what you want it to do. Planning with me means that your plan is going to work when your family needs it to work. And really, it's a gift that you're giving to the people that you love the most. So what should this cost? And I understand that this is something that is really concerning to a lot of people. A lot of people think I'm going to have to work with an attorney. It's going to cost a lot, but I'm going to show you that it does not have to cost. It does not have to cost as much as you think it's going to cost. But first, I want to set a little bit of context. If all you have is a house that's worth $400,000, this planning is going to save your family at least $12,000. And the way that I got that figure, I just took 3%. Remember, that's on the low end of what probate might cost. Generally, when you have a smaller estate, it costs towards the higher end. But I took 3%. $400,000, and that's $12,000 that your family would have to pay to get through probate just with that one asset, just with that house. If you have assets over $3 million, then this planning will save your family at least 13 cents on the dollar for every dollar in excess of $3 million. The typical death plan with a typical estate planning attorney is going to cost $1,500 bare minimum. There's no attorney doing this for less than $1,500. And if they're doing it for less than $1,500, you should be extremely skeptical about what kind of, crackerjack will they are going to be writing for you. But that typical death planning attorney, you can be almost guaranteed it's not going to keep your family out of court and conflict. It's not going to ensure that your assets aren't lost to the State Department of Unclaimed Property. Again, that's just not something that most estate planning attorneys think about or worry about. And it's only going to cover your money. It's not going to cover your kids' immediate care. It's not going to cover your values, your insights, stories, or experiences, those most important, those most valuable intangible assets that are the most often lost assets. But planning with me, a personal family lawyer, you can learn exactly what your family needs, and you can choose your own fee, likely to range somewhere between $2,000 and $8,000. And in that case, you're going to know that your plan is going to work when your family needs it to work. And I want to make this really easy for you. I want to share with everyone here this link that I have up on the screen right now at the bottom of the screen, which is where you can go and actually see my schedule. And you can see that my time here in September already is somewhat limited. But you can click through that link. Make sure if somebody can't see the link, make sure that you let me know so that I can post it again. But I want to make this really easy for you with these offers. I want to give you the full family wealth planning session for absolutely free. And the family wealth planning session has a $750 value because it means working with me for 3 hours to talk about the people that you love and everything you have. And I am going to help you to know exactly, specifically, what is going to happen in your family when something happens to you. There is some homework that I want you to finish in advance of our meeting, in advance of that family wealth planning session. But you can complete that homework. It's not going to be too difficult or too onerous. And get that family wealth planning session, again, for absolutely free. It's a 2-hour working session. In the first half of it, the first hour of that session, we're going to go through some different things that you should probably consider. We're going to talk about unclaimed property and how those assets get to unclaimed property, and whether any of your assets might be subject to going to that unclaimed property, or who can step in and make sure that everything is gathered up, and how we can create an inventory to make sure that everything gets to who you want it to go to. And we'll talk about incapacity, and we'll talk about what the court cases look like in order to determine who can make healthcare decisions for you or who can make financial decisions for you. And again, how you can get those things in place in advance so that you can actually be the one in charge of choosing who can make those decisions for you without having to leave it up to a court. And we'll talk about probate, and we'll talk about exactly what probate would mean for your family and what that would look like. And we'll talk about estate taxes. And we'll talk about whether you're subject to estate taxes, whether you might be subject to estate taxes in the future, if there are changes in the law, or if there are changes in your assets. We'll talk about exactly what we can do about it and how we can protect your assets as much as possible. And we'll talk about how you want people to receive, and whether the people in your family are ready to receive, whether they are already financially independent and have a good financial sense of the world, or if they are not ready to handle money, and exactly what we can do to make sure that we protect that money and that we shepherd it in the right way, and that we are taking care of it in the right way. And I see somebody is saying, can you post the link in the chat? I didn't get it. And so there, I just sent it to everybody. Hopefully everybody is able to see it now and able to click through it. That's that family wealth planning session. The second half of the family wealth planning session is where we design a custom estate plan that is directly tailored to your family, and that is taking care of your family in exactly the way that you want them taken care of. That's really your opportunity to take control and be guided through the process of getting an estate plan in place that's going to take care of the people that you love. I don't want to just give you that family wealth planning session for free. I want to give you something in addition. And I did see your question just a little bit ago, and I will address it just a second, I promise. The second thing that I want to give you is $250 towards the estate plan of your choice. And so if we have that meeting and you say, yes, I do want to continue, and this is the plan that I want to do. I'm going to take $250 off whatever plan it is that you choose. The only thing that I'm going to ask you to do is that you get your meeting reserved by the end of the week. Doesn't mean that your meeting has to occur before the end of the week, but I just want you to get on my calendar before the end of the day Saturday. And as long as you get on my calendar before the end of the day Saturday, then I'm happy to give you that $250 towards the custom plan of your choice. And really the reason for that is because you're here and you are educating yourself about this topic. And I can tell you the people that I love working with the most are the people who are putting themselves out there and educating themselves and making sure that they know about this topic. And because you're here and educating yourself, I want to reward that. But I also want to give you something to make sure that you keep the momentum going and that I don't have to pursue you. I don't have to chase you down to make sure that you get an estate plan in place, because I'm just not going to do that. It's not my place. Once we get working together, I'll make sure that you stay motivated and I'll make sure to keep contact with you. But this is, I need you to bring, to get yourself on my calendar and to get into the process so that we can start working together. So I'm not seeing anybody else saying that they can't access the link. Hopefully everyone's been able to access it. I've posted it a couple of times in the chat box now. And I really want you to click through and take a look at the calendar and see if there's anything on there that's going to work for you. I know that September looks pretty picked over right now, but there is some time in October, and I believe there are even some Saturdays that are available in November and December if you want to look that far ahead and plan that far ahead, if having a Saturday meeting is really important to you. So these are your next steps. I want you to schedule your free family wealth planning session by clicking through that link. And then I want you to use that $250 gift towards the plan of your choice. And as I said, I did see this question here, and I'm going to go ahead and answer it right now. The question is, what's the difference between a living will and a healthcare directive? And I have to say that is a fantastic question. Healthcare directive allows you to do two things. Healthcare directive allows you to name a healthcare agent who can make healthcare decisions for you. And a healthcare directive also enables you to list exactly what you want from your healthcare. So you can list out, I want this treatment, not this treatment. I want this. I want my healthcare agent and my doctor to think about this when I'm in this situation, and to go through those kinds of questions. And that second part is called the living will. The living will is not where you name a healthcare agent, but it is where you name exactly what you want from your healthcare, and you make it really clear to your doctor and to your healthcare agent exactly the choices that you would have. So fantastic question. Again, if anyone else has any questions, I'm really happy to answer them. But I will talk about just some of the other questions that I get. One of the questions that I get is, how does the family wealth planning session happen? Does it happen in person? Do you have an office somewhere there in Bloomington that we have to come to? What is the situation? In the family wealth planning session can be totally virtual. In fact, that is typically what I've been doing right now, is meeting totally virtually, which is really convenient for people. And I know that we all have some Zoom fatigue going on right now, but it really is a great way for us to meet and get acquainted, to start out and to be able to talk through exactly what you want from an estate plan and how to get taken care of. Another question that I have coming through here, do you recommend physician's order or something like that? And I believe if you're talking about a physician's order, if you're talking about like a DNR or something like that, it really depends on the person's circumstances whether a DNR makes sense. That's a do not resuscitate, where you would need a physician to sign off on it. Again, I'm not totally sure that that's what you're asking about. If you're asking about something else, I hope that you'll let me know. But it is very subjective to the person whether that makes sense and whether that's something that is that's desirable or not. But it is something that I talk through with my clients if that's a concern of theirs. Generally, the healthcare directive and the living will portion is a little bit more general than that, and is speaking a little bit more generally towards your care. Another question here, the duplex or in regards to the duplex I own with my sister, her husband and daughter, what rights do they have to my sister's half of the property? Because you own it in joint tenancy with your sister, the husband and daughter do not have any rights to that property. And that's especially true if your sister or if your sister's husband, if your sister is not living in the property. If your sister is currently living in the property, or if her husband is currently living in the property, or if her daughter is dependent on your sister, then they may have some right to continue living in the property. And that's something that I'd have to evaluate based on the context and based on the facts of your situation. But there are, I know, some sometimes written into the statutes, some ways that dependents and spouses can continue living in a property that they've considered their home and considered their homestead, so that they can continue living in it for the rest of their lives. So very good question. But generally, joint tenancy, stuff that's owned in joint tenancy, just goes by order of law. Just happens automatically that it goes to whoever the joint tenant is. Another question that I often get is about special needs trusts. And it's a particular area of concern to people who have somebody who has special needs in their family, or somebody who's disabled in their family. And the reason is oftentimes somebody with special needs or supplemental needs is going to be receiving some support from the government. They're receiving some kind of government benefit. Maybe it's for their food, maybe it's for their shelter. Maybe it is more all-encompassing than that. Maybe they have a personal care attendant or something like that. And in order to qualify for those government benefits, their assets and their income have to be at a certain level. And so you can imagine if somebody received an inheritance who was receiving benefits from the government and they were required to have their assets at a certain level, it can be really a bad situation for that person with special needs or supplemental needs, because they're going to get bounced off of that government benefit and they're going to have to reapply for it when they qualify again. And oftentimes that means just spending down their entire inheritance on things that the government was providing anyways. And then finally, when they get everything spent down, that's when they can finally reapply. And there's usually a waiting process where you actually have to reapply, and it takes some time to get approved and to start receiving those benefits again. And so if you have somebody in your family who has special needs, or if you know somebody who has special needs, this is something that you really want to think about, and something that you really want to make sure that you take care of. The special needs trust can actually hold those assets for that special needs person in order to make sure that those government benefits don't get cut off, and that inheritance that you want them to receive can be used for supplemental things and extra things that the government is not providing for them. I have a question here. A POLST, physician's orders for life-sustaining treatment, is what I am hoping to get your opinion on. And yes, a POLST is sometimes a physician's order for life-sustaining treatment is sometimes advisable. But again, it's not something that I generally work with, because the physician is really the one who's driving those documents and is driving the signing of those documents. It's really going to depend on what you want from your healthcare and what concerns about it that you have, whether that POLST makes sense or not. Generally, I write healthcare directives for people, which can provide some information, and generally, I don't do planning with POLSTs. It hasn't been a priority. It hasn't been something that my clients have been concerned enough with to go to that level and to make sure to get that done. It's a really good question. If it's something that you're concerned about, or if it's something that you know that a family member has done or might do or might need, I hope that you'll reach out to me and we can talk about that context some more, and figure out why it was done that way. So I said near the beginning that everybody needs an estate plan. If you're 18 years or older, you really need to have an estate plan in place. And there are a couple of documents, I think, in particular, that are really important to get in place when you turn 18 years old. And that's a power of attorney and a healthcare directive. So you can imagine an 18-year-old going to college for the first time. If something happened to that 18-year-old and they found themselves in the hospital, it could be very difficult for their parents to find out information about where they are and about what is going on with their health. They're an adult when they turn 18. And that means that they have the ability to keep their records concealed if that's what they want to have happen. Power of attorney also makes sure that a parent can help them to make financial decisions. So if they end up in the hospital, but they need their rent to continue being paid, you've got to have a power of attorney in order for that parent to write the check out of their child's bank account. I know that that's often not the way that kids at college are having their rent paid. Oftentimes it's the parent who is paying it directly or the parent who's paying it through the child. But that power of attorney can be really important, especially for financially independent children who might have something happen and need to have some continuity with the payments that they're making. Another question that I often get is about nursing home care and concerns about the costs of nursing home care. And I completely understand those concerns. Nursing home care is extremely expensive and seems like it's just getting more and more expensive every year. And so it is something that I am able to address, and it's something that I'm able to help plan for my clients. Sometimes long-term care insurance might make the most sense. Sometimes getting a long-term care insurance policy, especially if you're young, can make the most sense. But sometimes there are situations where long-term care insurance is no longer a possibility, or it's either no longer a possibility or it's so expensive that it's just not feasible. And if that's the case, there are some legal things that we can do to start planning and to start arranging assets in a way that takes care of your assets to the maximum extent possible. I see that somebody posted something that is confidential, and I'm not sure that that they want me to answer that or not. Yeah, you just don't want your name to appear. Good, and it does not appear here. But the question is, if I receive medical assistance, how do I leave my assets to my 2 nieces and 1 nephew? Is it even possible? Minnesota will want to recoup money spent on me over many years. I have very little. Can I leave anything to my nieces and nephew? And that's a really good question. It's something I hope that you'll reach out to me directly and that we can talk about a little bit more over either a phone call or in that family wealth planning session. It's difficult for somebody with medical assistance or who's receiving medical assistance in Minnesota to be able to pass things on to the people that they love. And the reason is that in Minnesota, we do have something called estate recovery, where the Minnesota wants to recover from your estate for the medical assistance that they've provided to you over your lifetime. But there are some ways that you can start to make some transfers to those individuals. And we can talk about exactly what that looks like and how you can structure those in a way that you're able to transfer those structures where maybe you're able to receive some benefits from them and able to give them some money in exchange. So again, I hope that you'll reach out. And I'm sorry, I have another question here that I missed for a little bit. What was the second one for 18-year-olds? And the 2 documents that I really recommend for 18-year-olds are a power of attorney and a healthcare directive. And the healthcare directive not only names the healthcare agent, but also says what they would want from their healthcare. And so it kind of lays out what they would want if they were in a vegetative state, for example, like Terri Schiavo had been in. Would they want their life to be sustained, or would they want to be able to be let to die and not a lot of people feel like they would be a burden on their family. And so they can make those kinds of decisions in a healthcare directive. It's really difficult decisions for an 18-year-old to make, but the really essential parts are having a healthcare agent and having an attorney in fact or a power of attorney in place that can help to make those types of healthcare and financial decisions for that person who's 18. Healthcare agent, the healthcare directive also authorizes the healthcare agent to access the healthcare records for that person, and that is that's really important. Again, if it's a parent that they're giving that healthcare agent to, that somebody has the ability to find out what's going on with that child and to know exactly what the situation is where they are. All right. I'm not seeing any other questions. I'm going to make myself big here just for a second, just so that you all can see me looking a little bit bigger here, and you can see my face a little bit better. Any other questions that are on people's minds? I'm really happy to answer any more. I see somebody saying, I still want to stay after. Are you talking about here and answering these, having these questions posed and answered? Or maybe you're talking about getting on my calendar and healthcare directive. Yeah. I still want to stay after and healthcare directive. Yep. I'm not exactly sure what that means, but yes, the healthcare directive is very important to make sure that you get that done if you are 18 years or older. Guide list, how did you want to do that? Oh, okay, I got you. So reach out to me, and you should see on my link. You can either schedule the full family wealth planning session, and we can make sure that we talk about it in there, or you can schedule a 15-minute phone consultation with me, and I'm really happy to talk in that 15-minute phone consultation about whatever that you want to talk about, including making sure to provide some guidance and understand exactly how to execute that healthcare directive. I believe that was for your mom, if I remember correctly. So I have here, so I receive extra benefits from the state. I'm thinking I should end those services to try and save from the state recouping money. Again, that's something that we can talk about. Oftentimes, if you've already started to receive medical assistance, oftentimes those medical assistance amounts can really escalate and can really make it difficult to get back on top of that estate recovery. But we can talk about that again. If you want to schedule a phone consultation with me, or if you want to schedule a full family wealth planning session, I'd be really happy to talk about that and talk about what the situation looks like for you, and how we can do things to provide the most to the people that you want to provide it to. I should keep benefits to a minimum so I don't lose so much assets down the road. Yep. Yeah, we can definitely talk about that. I'd be really happy to talk about that with you. And I see somebody else saying, okay, cool beans, I get it now. Yes, for mom, 70 years and surgery on knee next month. Well, I'll keep her in my prayers that the knee surgery goes well. I've had knee surgery myself, and it's not fun, but it's something that those orthopedic surgeons, they know how to take care of it and know how to get people through. So again, I'll pray for her and make sure that I hope that it goes really well. All right. I'm not seeing any other questions coming through. Again, I really hope that you will click through if you haven't already and take a look at my calendar. I'll also send out a link to the calendar in the email with the recording, and so you can look for it there. And then I'll email one more time on the last day, just to make sure that everybody has had ample warning and ample time to get on my calendar and schedule with me. But again, my name is TJ Scott. I really thank you for sharing this time with me tonight and getting to learn about this important topic. This is so important. We're all going to die someday, and that is so dark. What a dark way to end this, but it's the truth, and it's something that we can face with confidence and face and know that we're doing the right things for our families, or it's something that we can hide from. And unfortunately, if we hide from it, our families are going to suffer for it. So I really want to congratulate you on being here and facing it with me. You've been a fantastic group, and I look forward to meeting you one-on-one, and have a great rest of your evening. Take care.